All right, good evening. Hi, everybody. Welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Litigation Whiteboard. Yes. All right, so we are talking in this video about involuntary dismissals under F.R.C.P. Federal Rules of Civil Procedure, Rule 41. 41, okay, remember that. This is important when you get into a case. Let's say you're a defendant. There's big, long delays. There's things going on, weird things, nothing's happening. Let's take a look at Rule 41, Involuntary Dismissal, and let's head to the Attorney Steve Litigation Whiteboard. All right, here we go. So let's take a look at this now. So we know in court, when you're in court, there's this timeline of all these things got to happen. You got to file your complaints. You got to get it served. You got to file an answer or motion to dismiss. You got to keep the case moving. And judges whether it's a state court or a federal court, we're talking about federal court rules here with the Federal Rules of Civil Procedure. But the judges want to keep the cases moving, keep the docket going, So when you have unreasonable delays, you have people not following the rules, you have court orders that litigants or plaintiffs or the clients are not following. This is a good time to think about and say, hey, I remember Attorney Steve talking about this in one of his videos. Rule 41, involuntary dismissals, okay? So one good ground that you might see is a summons and complaint. So when you file a case, you have a complaint that lays out all your problems, and you have your summons, which is basically the court saying, come in here, you are summoned to come here and answer or respond to the complaint and tell us your side of the story. But you have a certain limited time. For example, under the Federal Rules of Civil Procedure, 90 days. This is under Rule 4M. M as in musketeer, 90 days, get it served, or you need to seek an extension of time. Tell the judge why it's taking so long. I can't find the defendant. They're hiding out. We're doing a stakeout, something like that. But there's other grounds, though. Anytime you are in a litigation case and you see unreasonable delay, okay, you see litigants not following court orders. You see a court saying you have to do something by this date. Maybe it's go to mediation. You need to ordering the parties to mediation. And then they sit around for 3-4 months and they can't even pick a mediator. Okay, things like that. Dilatory conduct, bad faith conduct. For example, say you have someone, we've got touched on that, somebody's not following the F.R.C.P, let's say. One of those rules is good faith filing. All your filings need to be in good faith. So maybe somebody's not filing that rule. You say, you know what, I'm going to take a shot at it. I'm going to file a motion to dismiss. This case has been going on, a long time now. I haven't been served. They're not following the rules. This is like, I'm going to take a shot at a motion to dismiss. So there it is. You would go ahead and file your motion to dismiss. Check your local rules. Don't miss your meet and confer. Call the other party. If you try to sneak this into the court, it's never going to go so well. And normally your local rules are going to require you to meet and confer, usually in person, as they say, but the phone is often permitted. So there may be a meet and confer requirement, points and authorities, your declarations, things like that. That's all part of your motion process. But here it is. These are grounds where you can come to the court and say, you know what, this has been unreasonable, Judge. I'm asking you to dismiss the case. Now, the court also has the inherent power to run and manage the court system, the inherent power to kick a case out if they want. So it doesn't always have to be by a party motion. Sometimes a judge can do that on his or her own motion, okay? And what are you looking for? You're looking for a dismissal. And usually if you're a defendant, you're looking for a dismissal with prejudice, which means you cannot bring the case again. Now, the plaintiff may be saying, okay, I messed up. I was busy. Don't make it a dismissal with prejudice. Make it without prejudice, meaning maybe I can bring it back again in a couple months when I'm feeling better or something else. So that's the basics. Now, realize there is no age limit, as we call it, for a case. There's no case that says, well, you can only do failure to prosecute after 250 days. There is no minimum age requirement, okay? So it can bring it on anytime you see this bad faith, dilatory conduct, delays, things that are just raising the cost of litigation. That's the time you think about your litigator's toolbox and you say, Attorney Steve told me Rule 41. Yes, that could be the ticket, okay? So there you have it. That is a quick look. You now know more than anybody should know about Rule 41 and how that works in federal court. Remember, this is federal, and there's also state courts with their own rules, but we're talking about the federal rules where we do a lot of our business in the copyright intellectual property area. So this is general legal information only, not legal advice. If you need some help, you need to hire litigation counsel, you know where to find us on the web at attorneysteve.com. It's attorneysteve.com, the first name in legal services, okay? Have a great day. I got to run. Dinner's on the table. Boy, it's been a crazy week already, but stay tuned. Make sure to subscribe. Punch that like button. We're going to hit 20,000 subscribers this year. It's going to be a great year for us all. And again, great videos, things that teach you something, not like politics, just hee-hawing all over the place. So hope you've enjoyed. Have a great day. We'll talk again.